just because a parent is out of work doesn't mean that they can walk away from their financial responsibilities to their children. What happens to child support if your ex isn't working and files for a modification? That's the question I'll be answering in today's video. So if your ex is not working or claims they can't find a job, they may try to modify an existing child support order. And this is a situation many parents find themselves facing, and it can be a stressful experience, especially if you're relying on that financial support to take care of your child. Now, in most states, including Georgia, either parent can request a modification, either upward or downward of child support, if there's been a significant change in circumstances. A change in income is one of the most common reasons people request a modification of child support. So if your ex loses their job, their immediate response may be to ask the court to lower their child support payments. While the court does take changes in financial circumstances into account on these kinds of issues, it doesn't always result in an automatic reduction of child support. The courts are tasked with balancing the needs of the child with the realities of the paying parent's financial situation. But just because a parent is out of work doesn't mean that they can walk away from their financial responsibilities to their children, because when the court lowers the child support payment for one parent, it's effectively increasing the payment for the other parent because the needs of the children are still going to stay the same. So let's talk for a minute about something called imputing income and discuss what it means and how it works. Now, if a parent is not working, the court may impute income to them. This essentially means that the court assigns them an income level based upon what they should be earning, even if they aren't currently employed. Now, when it comes to paying your taxes, that's based on what you're actually earning. But when it comes to calculating child support, the court can say, here's the income we're going to use. Now, when it comes to calculating child support, at the very minimum, the court will impute income based upon a full-time minimum wage job, but it will more often be based on their previous job income, their qualifications, or their earning potential. So let's say that they leave a prior good-paying job and get a job that pays much less and doesn't utilize their skills. Maybe it's just a more fun job, or they just don't feel like working the hard job that they might have had before, upon which the child support order that's currently in place was based. In this case, the court will likely base their imputed child support income on what someone with their qualifications and abilities could reasonably earn in the job market. This prevents someone from avoiding their financial obligations by working a lower paying job or choosing not to work at all. The courts look at many factors when determining whether to impute income, including these. First one they look at is a work history. What jobs has the parent held in the past? What's their skill set? What's their prior income level? The second factor that the courts look at is educational background. Does that parent have any special qualifications or certifications that would allow them to earn a higher wage? Third factor the courts look at is availability of jobs. Are there jobs available in the field that the parent has experience in or has education in? The court will often look at whether the parent has made an effort to seek employment. The key question that the court will consider in imputing income is whether the parent is capable of earning more but chooses not to deliberately. If your ex is trying to game the system by quitting or not seeking employment at their level of capability, that could backfire on them in court. It's important to understand that the best interest of the children is the court's primary concern. That trumps everything. The court wants to ensure that the child's financial needs are being met, and a parent's unwillingness to work or contribute financially will not be looked upon favorably. But what happens if they file for a modification? Well, if you find yourself in a situation where your ex has requested a child support modification, there are a few things you can do to protect your interests and your child's well-being. First thing, document their work history and qualifications. Gather any evidence that shows that your ex has the skills and or the education to earn more than they're currently making. This can include their resume, LinkedIn profile, pay stubs from prior jobs that you can actually get during the discovery process. Second thing to do is show the court job opportunities. You can present evidence of available job opportunities in your area that match your ex's qualifications. This can help support your argument in court that they should be able to find work and continue supporting your child. Now, I've done this on multiple occasions, surprised the opposing party in court. It worked like a charm because the other side was not expecting this. Third thing to do is monitor job search efforts. In some cases, a court may order the unemployed parent to show proof of the job search efforts. You can request this job search proof in the discovery process, and they have to turn it over to you. You can ask for just about anything reasonably related to this situation, including details of job applications, interviews they've gone on, phone calls, phone logs, all of these things to prove whether or not they're really trying to get another job at that income level that their current child support was based on. The fourth thing that you can do and should do for sure is seek legal guidance. Don't do this alone. It's crucial to have legal advice to navigate child support modifications. A strong, competent, confident family law attorney will have done this many times and knows the process, and they can help you understand your rights and ensure that your child's needs are being adequately considered. So what's the wrap-up takeaway from all of this? Here it is. In Georgia, courts take child support obligations very seriously, and losing a job doesn't automatically relieve somebody of their responsibility to provide support for their child. If your ex is not working and files for a modification, the court may impute their income based upon their earning potential. Your best course of action is to be prepared by hiring a great family law attorney, gathering evidence, and presenting a strong case. I hope you never have to face this, but if you do, now you know how to gain the edge in this situation. Thank you very much. Hey, thanks for watching. Please subscribe, like, follow, and turn on alerts to get notified of new videos. Share these videos and leave us comments, ask us questions, and let us know what topics you'd like for us to cover. Join our Facebook group at Georgia Divorce and Custody for even more information, and I look forward to seeing you on the next video.